Relying on beneficiary designations as an estate planning tool to avoid probate may be an attractive feature, but I did want to highlight some of the drawbacks to beneficiary designations. When you come to an estate planning attorney, some of the options that you have in front of you is whether or not you want your estate to pass through probate. If you want to avoid probate, you either need to set up a trust and transfer all your assets to that trust, or you need to rely specifically on beneficiary designations, which refers to naming a pay-on-death beneficiary on account or a transfer-on-death beneficiary for real estate, designating joint ownership. As long as you have joint owners, beneficiaries on every account, every asset that you have, then probate will be avoided. The attractive feature to it is that's very cheap. You don't need an attorney to go set all those up. You can go take care of the transfers yourself, except for real estate and business ownership and a few other assets. But things like bank accounts already have a very easy spot to designate beneficiaries. But they do have some drawbacks. Their simplicity can be an attractive feature, but also it can be a drawback, and it's worth considering if relying on beneficiary designations is right for you. It would be your preference. So some of the risks are that because the beneficiary designation is only instructions to the bank to write a check or to transfer ownership to the designated person, there's no contingencies there. There's no finesse. So that means that the money is going to that beneficiary without being first used for the costs of your administration. If you only have one beneficiary, maybe that's not that big a deal. But if you have multiple beneficiaries, what that means is it doesn't answer the question of who pays a funeral bill. Where's the money coming from? What if we need to spend money on your house, painting it and getting it ready for sale before it's sold? All of the beneficiaries receive their money. It's going to be up to them to work out how to cover those costs, who's in charge of it, whether or not they'll repay each other. If you're concerned about that, it's really not a good idea to rely on beneficiary designations. The second drawback is that it allows only for a limited amount of contingencies. Sometimes you can allow secondary beneficiaries and third or tertiary beneficiaries, but it doesn't allow for things like if this beneficiary is disabled, we want the funds to be held in a certain way, or if they're minor children, we don't want them to be receiving the money too soon. It doesn't allow for any contingencies. It's just instructions to write a check of that account to that person. So if it's important to you to make sure that your estate is used first for your costs of administration, taxes, expenses, the funeral bill, before it gets distributed to your beneficiaries, or if you want to make sure that you're allowing for protection from the beneficiaries. If they die, if they're disabled, if you have minor beneficiaries and you want to protect the money from the beneficiary, then I wouldn't recommend setting up beneficiary designations, and that you talk to your attorney about some alternatives, either setting up a will or a trust.